Mr. Chief Justice, and may it please the court. I am Elijah Johnson. I and my co-counsel, Aidan Gillissen, will be arguing on behalf of the petitioners. We are arguing that the University of North Carolina's race-conscious admissions policies are consistent with the 14th Amendment. This is evident when we see that institutions of higher education can indeed use race in the process of admissions as long as it is not the primary factor of selection. Race must be considered as a factor. However, it cannot be considered the sole factor on which a decision is made. Those of African-American descent need help not to get an upper leg on anyone else, but rather to even out the playing field. Those of African-American descent have gone through so much in the past that they should be given the equality of opportunity. This equality has been something that should be something that is sought for in American life. The equality of all people is highly valued and stapled in the Declaration of Independence.
There are four primary terms included in Section 1 of the 14th Amendment. The one that I would like to hone in on is the term equal protection.
So, counsel, since you're bringing it up, does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
Your Honor, no. The 14th Amendment was made to promote equality between races. This is well exemplified in history through the Freedmen's Bureau Act, where it gave aid to Black persons freed from bondage to help them become self-sufficient, which we see in the amicus brief of Constitutional Accountability Center. And for this reason, it does not prohibit race-conscious affirmative action. It was said in the brief of Harvard UNC that nothing in the original meaning of the 14th Amendment, not the Equal Protection Clause, not the Citizenship Clause, not the Due Process Clause, not the Privilege of Immunities Clause, clearly prohibits race-conscious admission policies. The 14th Amendment is there to ensure that all citizens are treated equal. This includes education. As was said in Grutter, education is important to citizenship. It is important in getting equality. And race-conscious theory is a way to ensure that everyone has access to that education, that citizenship, and overall, that equality.
So, counsel, how does legislation enacted by Congress in the 1860s and 1870s affect your answer to question 1?
Your Honor, the Reconstruction era for remediating the effects of slavery was designed to help the freedmen of the 1800s to get back on their feet without having to contend with so much. Instead, they were given privileges to help further their careers and lives. This is clearly seen in the act to incorporate Howard Institute and Home and the District of Columbia. The goal was to educate freedmen, and it was supported by the federal government, not just as a tax break, but it was actually funded by federal tax money. This is exactly what the University of North Carolina's policies are attempting to do as well. The evidence not only furthers the position of helping those minorities who are not afforded the same opportunities and privileges as others.
Okay, so let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years in a very different society?
Your Honor, yes. While there has been positive changes, there is still a certain level of racism and discrimination where changes still need to occur. UNC, the University of North Carolina, still has a smaller amount of African-American students than the state of North Carolina as a whole, where it is located. The University of North Carolina is made up of only approximately 7.7% of African-American students. This is not nearly as close as North Carolina's more diverse demographic of over 21% of North Carolina being African-American. African-Americans are still suffering from the events of the past and are still being discriminated against today. O'Connor and Grutter said that affirmative action was needed for another 25 years. It has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education. Since that time, the number of minority applicants with higher grades and test scores has indeed increased. We expect that 25 years from now, the use of racial preference will no longer be necessary to further the interests approved today. Therefore, student body diversity is a compelling state interest that can justify the use of race in university admissions.
Okay, since you brought it up, um, in 2003, as you mentioned, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
Your Honor, in an ideal world where there would never be any racism and all people would be able to enjoy the same opportunity. However, in this world that is imperfect, there will always be those who discriminate against those of a different race. There will always be those who have not had access to the best opportunities and tools to advance their careers in education. It would appear that racial preferences will always be needed. The only way to sufficiently counteract and combat that discrimination and lack of opportunity are these racial preferences. These have proven to give chances to minorities that may not have gotten the chance to excel.
All right, thank you, counsel. You may continue.
Your Honor, as we see in the amicus brief of professors of history and law, following the ratification of the 13th Amendment in 1865, many states in the South enacted discriminatory Black codes intended to confine Black people to the bottom rung of the social ladder. This was said by David C. Thompson. Equal protection.
Oh, sorry, you may finish.
Okay.
Counsel, yeah.
Equal protection means true equality to liberty and freedom is given to all. In order to get on an equal playing field for an African American, one must be given certain tools to help combat racism as well as the discrimination of current and past societies.
So, counsel, let's assume that the framers of the 14th Amendment thought that people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races such as Hispanics, Asians, and Native Americans could receive similar privileges?
Your Honor, in the report of the Joint Committee on Reconstruction at the first session, 39th Congress said it was impossible to abandon the newly freed states, or newly freed slaves, I should say, without securing them their rights as free men and citizens. Later on in that same session, they discussed the adoption of this amendment is essential to the protection of Union men who will have no security in the future except by force of national laws, giving them protection against those who have been at arms with each other. Once again, a little bit later in their discussion, they said white men have been driven from their homes and have had their lands confiscated in state courts under state laws, the crime of loyalty to their country. It says, arguing that all persons, whether citizens or strangers within this land, should have equal protection in every state in this union in the rights of liberty and property. To close their discussion, they said, we will protect Chinese aliens or any other aliens whom we allow to come here. Let them be protected by all laws and the same laws that other men are.
Your Honor, in summary, anyone who has been in a group who has been discriminated against needs to be helped and nourished at least some extent. There are certain levels in which segregation and racism may occur against other races, but there are undeniably different levels of segregation and racism that is different between the races. Slavery was the worst of which we have seen in this nation. Those of African American descent have gone through more than many can even imagine. Therefore, they are in a more dire need of support and help in today's society.
So, counsel, what would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
Your Honor, the framers would not be aware or familiar with the concepts of gender identity, and the sexual orientation that deviated from tradition was not in the sector of focus to the framers. In Grutter, we see O'Connor wrote that context matters when considering affirmative action. The government is working to fix the wrongs that have been done to those who are a part of the issue of sexual orientation or gender identity. An example of this is the Respect for Marriage Act being legalized. The amendments of the Constitution should only be used in dire social issues when there is no other change possible. We see that there have been much worse tragedies that have occurred to those of African American descent. The framers were more focused on creating a level playing ground based on fairness for all. This entails the idea of giving extra help to those who have not been given that equality and have been bashed down in the past.
All right, thank you, counsel. You may continue with your argument.
Your Honor, second part of our argument was, while this race-conscious affirmative action is in short a form of reparation for past mistreatments, helping those who have been put down in history and bolstering those same individuals to help them achieve their fullest potential. Now, this doesn't mean the United States gives those of different ethnicities purely just money. It means it gives them equality of opportunity, as we said before. In the late 80s, a bill was drafted to help with the reparations of slavery and those it impacted. Representative Conyers introduced this bill in November of 1989, and the preamble read, "To acknowledge the fundamental injustice, cruelty, brutality, and humanity of slavery in the United States and the 13 American colonies between 1619 and 1865, to establish a commission to examine the institution of slavery, subsequent de jure and de facto economic discrimination against African Americans, and the impact of these forces on living African Americans, to make recommendations to the Congress on appropriate remedies and for other purposes." Your Honor, the idea of this shows that it is not exclusively against those of the white race, but it is a reparation to the United States as a whole.
But counsel, does Brown versus Board of Education prohibit race-conscious affirmative action? Please make sure to also address Bach and Grutter.
Brown prohibited separate but equal. Plessy versus Ferguson said that as long as you have equal schools, you can have segregated schools. Affirmative action is seeking to fix the educational harm that some students face due to their race. In Grutter, it is said that we have repeatedly acknowledged the overriding importance of preparing students for work and citizenship, describing education as pivotal to sustaining our political and cultural heritage, with a fundamental role in maintaining the fabric of society. This court has long recognized that education is the very foundation of good citizenship, as it was said in Flyer versus Stowe. Brown versus Board of Education said, "For this reason, the diffusion of knowledge and opportunity through public institutions of higher education must be accessible to all individuals, regardless of race or ethnicity."
Your Honor, to add on to what my co-counsel stated, we see that Bach said, the fourth goal asserted by petitioner is the attainment of a diverse student body. This clearly is a constitutionally permissible goal for an institution of higher education. Academic freedom, though not a specifically enumerated constitutional right, long has been viewed as a special concern of the First Amendment. The freedom of a university to make its own judgments as to education includes the selection of its student body.
Sorry, I forgot to unmute. So I have another question, I guess, to follow up. Should Grutter versus Boehlinger be overruled? Please address the Supreme Court's recent discussion of stare decisis in Dobbs versus Jackson Women's Health Organization.
Your Honor, Roe versus Wade was overturned because there was little right before the second half of the 20th century, and there was little discussion in the Constitution about this issue. Race is a part of the Constitution, and discrimination due to race is being heavily looked out for in the Constitution in order to create a state of equality and fairness for all American citizens. Justice Kagan wrote in her dissent in Dobbs versus Jackson Women's Health Organization, "Stare decisis is the Latin phrase for a foundation stone of rule of law, that things decided should stay decided unless there is a very good reason for change. It is a doctrine of judicial modesty and humility." She is saying that remaining consistent with the decisions made by previous Supreme Courts will ensure the best decisions are being made by the current Supreme Court. Constantly changing the established law will lead to bedlam. Alito explained that a right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. Washington versus Glucksberg is where this was stated. The right to abortion does not fall within this category until the latter part of the 20th century. Such a right was entirely known in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the United States made abortion a crime at all stages of pregnancy, as was stated in Dobbs versus Jackson. So in sum, Your Honor, we urge the court not to overrule Rudder. Abortion was not even considered in the Constitution until many years later, because the idea of equality was so well stated and prioritized that if law is overturned so often, it will lead to inconsistency, confusion, and mayhem. Law stating that admission influence based on race is justifiable and legal, overturning it not even 20 years later, will show inconsistency in the court.
So, counsel, on that note, if the court declines to overrule Rudder, can the plaintiffs prevail?
Your Honor, they cannot prevail. By remaining consistent with previous court decisions and not overruling Rudder, the argument for having a non-diverse school community is a concerning argument to make. The intention of making a wiser and more equitable school and society should be desired by all. By not overruling Rudder, the court promotes a more well-rounded and non-discriminatory society because the 14th Amendment does not prohibit any kind of bolstering of any mistreated or degraded race. Race-conscious admission consideration is consistent with the 14th Amendment because it is not discriminatory at all. It is merely attempts to raise all races to an equal plateau of opportunity. As it was previously stated in the first question, there is nothing in any of the clauses of the 14th Amendment that prohibits these types of policies.
All right, one last question. If the court overrules Rudder, will the military have difficulty recruiting a diverse armed services?
Your Honor, if the court decides to overrule Rudder, it can be presumed that the military will have difficulty recruiting those of different ethnicities. Education and influence will have a great effect over the younger generations of children. If the influence on them is one of a discriminatory nature, they will not want to go into the military. The military is a predominantly white organization, according to recent statistics. It is also an organization that has a very clear hierarchy structure that is and should be based on intelligence, skill, and grit of an individual. However, if there's a clear bias against those of a different race, it will be astonishingly difficult, nigh on impossible, for African Americans and other races to progress or rise in the ranks. This is clearly seen from the experience of General Charles Brown Jr., the first Black service chief in U.S. military history and current Air Force Chief of Staff, who said, because of a lack of diverse authority, he had to work twice as hard. Those of different ethnicities will be denied opportunities at areas of expertise or leadership opportunities, not because of their competence or intelligence, but simply because of the color of their skin. This will radically change the population of the military and definitely decrease the diversity. It will decrease because those of a different race will not want to spend so much of their time working so hard when their efforts will not even be considered for to be rewarded.
All right, thank you, counsel. You may continue with your argument.
Your Honor, that concludes our argument. And for the foregoing reasons, we respectfully request that the court find in favor of the University of North Carolina and rule that race-conscious affirmative action is consistent with the 14th Amendment to the United States Constitution.